Welcome back, everybody. Testimony continued today in the stop and frisk case. On trial, as you know, the NYPD's controversial policy of stop and frisk. It's a policing tactic which allows officers to stop, question, and frisk people that they deem suspicious looking, and it's that vague definition that has gotten us to where we are. 5 million people have been stopped in the practice. Now, the class action lawsuit originated with 4 men who argue that the NYPD stops a disproportionate number of those people are either of black or Hispanic men without cause. The suit, it seeks to reform, not ban altogether the practice, but to change it. Last night, in fact, we had mayoral hopeful Bill Thompson, who said that he'd keep part of it, but he would amend it. Now, during last week's testimony, we heard from several men who were stopped and frisked, and police officers who said that they were pushed to fill quotas. Notably, we also heard a surreptitiously recorded conversation between a police inspector and his subordinate. Now, some have pointed to this recording as a centerpiece of the case. On the recording, you can hear Police Inspector Christopher McCormack saying, quote, "We go out there and we summons people, the right people at the right time, the right location." The subordinate, Officer Serrano, then presses McCormack about who he means are the right people. Take a listen to his answer.
This is about stopping the right people, the right place, the right location.
Okay.
Again, take Mott Haven where we had the most problems.
Right.
And most problems we had there was robberies and grand larcenies.
And who are those people robbing?
The problem was what? Male blacks, and I told you the roll call, and I have no problem telling you this. Male blacks 14 to 20, 21.
Now, some, including New York Police Commissioner Ray Kelly, says the recording taken out of context. Our own Dominic Carter, he spoke with the attorney for the plaintiffs today, and he joins us now with more. Dominic, at least you're not freezing as much as normal down there. Tell us what happened in the courtroom.
Well, good evening to you, Richard, from Lower Manhattan. Week number 2 for this trial, but frankly, all day long, it was another bad day for the NYPD. Now, Richard, one officer, Brian Dennis, admitted that he taunted an innocent 13-year-old boy he had detained and handcuffed while responding to 911 calls about a disorderly crowd in a Harlem area. The officer admitted, Richard, that he told the handcuffed 13-year-old, the son of a retired officer, to stop crying, quote, like a little girl, and admitted under cross-examination if he thought the comment was appropriate. The officer responded, looking back, no. Now, let me show you one memo here, Richard. This is what amounted to what the plaintiffs are saying is a big day for them. This is an NYPD memo that went out to the entire department, police department, from the chief of department. And in this memo, it illustrates, we've heard a lot about 250s. As you've pointed out, Richard, those are the forms that officers fill out every time they make one of those stops, the 5 million, the figure that we have heard from officials. But what the plaintiffs are hailing as a major victory for their side is no longer will officers just be able to check a box on did they make the stop. They're going to have to be forced to explain the suspicious activity of why they stopped an individual. So back to the comment of where you started, Richard, and that is the secretly recorded tape of an NYPD deputy inspector saying on tape to stop male blacks 14 to 21. The police commissioner says that was taken out of context.
Inspector McCormack was unfairly criticized by the media, in my judgment, because his entire statement, the recorded statement, was not published. It was cherry-picked, in my judgment, to make out a case for racial profiling. If you read the inspector's statement, it makes absolute sense. He was talking about a robbery pattern in the precinct. He was singled out by the media and as I say, I think unjustly criticized.
Male black 14 to 21. He says the deputy inspector's testimony was misconstrued, taken out of context.
Well, I mean, the deputy inspector's testimony is his words. It's not us saying it. It's not Serrano saying it. It's his words. I mean, you heard the words in court. And he said, I have no problem saying this. I said it at the roll call. We're looking for the right people at the right place at the right time. That's male blacks 14 to 20, 21. That's what he said. Those are his words. Everybody knows what that means.
Well, let's talk about this police department memo dated March 5th of this year, in which now they're going to have to document the explanation of suspicion. Is this a victory, a partial victory? If so, why?
Well, I think it's certainly an admission. It's what we've been saying they should do all along, and it's what part of what the relief is that we're seeking in this case. And it's not coincidental, I think, that this memo was written the day after we submitted our brief to Judge Shinlin saying this is the kind of relief we wanted. I think they're trying to, as they say in legal terms, trying to moot out our claim for relief. We don't think that does that, but it's important that they do it. They can't ever look back at a stop and determine whether there's reasonable suspicion if they don't have the details. Just checking off a form doesn't allow you to do anything other than record the fact that something happened. It doesn't allow you to look critically at whether there was in fact reasonable suspicion to stop anybody.
So, Richard, again, lead counsel for the plaintiffs claiming victory because the NYPD, dated March 5th of this month, has changed their policy on this form. Officers must now detail why, in writing, they felt something or that someone was doing was suspicious. So one of the witnesses, Richard, in conclusion, scheduled to testify today, someone you know very well. You've interviewed him repeatedly. That's State Senator Eric Adams, an outspoken critic of the police department. He was supposed to be here, but got out of testifying because of the ongoing budget situation. We're told by lead counsel for the plaintiffs that Eric Adams, the state senator, may be here tomorrow. That is it from Lower Manhattan. I'm Dominic Carter. Richard, let's go back to you.
That's right. And Dominic is going to be hosting Friday. He's going to be interviewing Eric Adams on Friday. Thank you, Dominic. Talking a little bit. Listen, Andrew and I get into politics of this all the time. We both know in all likelihood the next mayor, regardless of what the court does, is going to amend this policy one way or the other. But likely it's going to stay in one shape or form. Let me ask you, Brandon, if it's your 13-year-old kid, right, who's basically walking while black.
Exactly.
Does this policy have a place in policing?
You know, I'll say this. I take offense to it for an officer to generalize that 14 to 21 as an African American means that you are a threat. Normally, I actually support many positions. I even support stop and frisk to an extent, looking back in how even the mirror effect works in terms of reducing crime. But I think this is the issue with stop and frisk, is that if a person is actually doing something wrong, then you have every right to stop that individual. But anytime you generalize, and the man said it, I mean, he spoke it out of his words, that, you know, any black male 14 through 21, you know, thank God I wasn't under 21, or I may be in handcuffs right now. So I think it's really appalling to know that there are members within the NYPD who think like this and patrol our streets in areas like Brooklyn and Harlem. And not to mention, let me also say, I think one of the issues is that, and I think the community portion, the community building portion aspect of the NYPD, I think that's what's missing. These cops don't have relationships in many of these urban communities. And I think until that happens, you're going to see and continue to see more of this. And so I commend the forms now of actually having to put why you stopped somebody or why you arrested someone. But I think we're about 10 years too late.
Mark, I know we're up against a break, Lisa, but if you can put down furtive movement under this new thing, which is one of the old uses, those two words, furtive movement, and the four of us can debate what that even means, okay? But basically it means whatever you want it to. It does. No matter what form they have you fill out, it's the same thing at the end of the day, isn't it?
Here's the real problem with this. Many of the viewers may not know that Supreme Court precedent and New York State precedent allows police officers to make pretext stops. Their subjective, their personal motivation for making the stop doesn't matter as long as they can articulate some sort of reasonable suspicion that would give an average police officer reason to suspect a crime has been committed. Until that case law changes, we're going to keep coming up with this over and over and over again. It's a systemic problem.
And again, we will be heading back to Lower Manhattan tomorrow for more on this as we continue to cover this case. And as I said, the number to remember, 5 million. 5 million people have been stopped and frisked, and about 90% of them people of color, and about 90% of them have been found completely innocent of everything. So keep those numbers in mind. We take a quick break, but when we come back, you heard our earlier guest talk about Roe v. Wade. Is that controversial issue? Well, That issue is once again, and it's never settled, it is once again in the headlines, this time in South Dakota. I'll tell you why at home, and our next guest will as well, why it should matter to you. Stay with us.